we have the hardcore group because you guys are here during lunch, so I appreciate that. We're going to do brief introductions, and then we're going to jump into it because there's a lot to go over, and there's a lot to learn. So my name is Jonathan C. Dunsmoor of Dunsmoor Law. I have a little practice out of Buffalo, New York, but I bounce around the world and try to see what you degens are coming up with so that we can help educate regulators and hopefully make the things that you guys are doing legal. We have tried to educate everyone from the CFTC, SEC, and FinCEN, and so far we've done a pretty good job, but we've got a lot more to do. And with that, I'll move the panel along.
Thank you. I'm John Shaw. I work at Fidansti, and I specialize in IP law. I contributed to the regulatory guidance that was published by the Law Society, and contributing again to the third edition that's hopefully going to be published early next year. And yeah, just have a real interest in the IP issues that are related to NFTs, blockchain, and the metaverse, particularly the licensing. And so hopefully we'll have a brief discussion about that.
Okay, well, thanks, John. My name's Jorge Franco. I'm actually a New York attorney. I practice primarily with regards to commercial litigation and insurance defense. It just so happens that, in my spare time, I happen to research the sexiness of international personal jurisdiction issues with regards to crypto and Web3. So that's largely what I'm going to be presenting on today.
Hi, I'm Chris. I'm a media regulatory lawyer based in Hamburg, Germany at DLA Piper.
Yes, hi, and my name is Nico. I'm also a lawyer at DLA Piper. I'm more a digital business lawyer, so I help clients implement digital business models. Yeah, glad to be here.
All right, with that, we're going to jump in. So the biggest question that we get generally is regulation. Is this a security? We've had other panelists talk about that, but what do we look at generally when it comes to the side of NFTs? George, like how are you looking at it from a U.S. perspective? Because as a U.S. lawyer, we know that the SEC loves thinking everything is a security.
Yeah, it's a bit interesting because, to disclaim that notion that everything is a security, we look to Bitcoin. Bitcoin is actually considered a commodity in which it's regulated by the commodities exchange and whatnot. And so determining whether or not it's a security, it's just sort of putting your hands up and saying, potentially.
I like to think that, we have to kind of do an analysis, right? And it looks at what is actually going on with the NFT. If there's tokens behind the NFT and you're staking them and you're using them later, what is, the entire kind of workflow of everything? And so it kind of just becomes this ever-evolving situation where you lovely folks kind of cook up ideas of how to use NFTs and how to use tokens in these new and novel ways, and then we have to kind of put it together. Nico, what are you seeing from your perspective as a business lawyer and all of the craziness in Europe?
I mean, I will hand over to Chris because Chris is the expert from the German perspective in this regard.
That's right, I apologize, Chris.
Thanks, Nico. So regulation, yeah, that's a hot topic. And the thing that is discussed most in Germany is how are NFTs actually regulated? And the catchphrase is utility token. If you make sure that it's straight up utility token, you have good arguments that the NFT is unregulated. So what does utility token mean? This will be defined in the upcoming MiCA regulation. And it basically means that the token offers access to goods or services. That's straight utility, and then it's unregulated, you don't need a license, you don't need a prospectus, and you don't need to do KYC for your customers. It's not utility if you promise investment opportunities, basically. So if you promise a return to your customers or a share in the company, or anything like that, it's not utility and it might be regulated. So that's when you need a lawyer.
Just to bring a question to that, what about upon completion of said promise? Would that then be considered utility?
That's a question.
So I forgot to do, before George gives out legal advice over here, none of this is legal advice. Do not do anything with this unless you have actually hired one of us or any of the other brilliant lawyers in the room because you may find yourself in trouble that we will not get you out of. But that being said, there are really interesting headaches around IP. So John, can you talk about some of those headaches that are involved, not only in this side of the pond, but all over?
Yeah, well, thanks so much. So I think there are three issues with IP, and I think the previous talk mentioned them, the talk before that as well. I think the key thing is understanding that the IP in the artwork doesn't necessarily transfer with the token when you own that code. People often mistake that. Then understanding that there's no one-size-fits-all license or assignment for every project. And then lastly, understanding the formalities, the legal formalities required in order to achieve the goals of the project. So, we skip point one because I think everybody's aware that the IP doesn't go with the art, or with the token rather. The next question is, do you want to? What are the goals of the project, and how will the IP transfer achieve those goals? Do you want to be having a Creative Commons license so anybody can use the art in any way just to promote the project, and you've just got the token, or the new owner just has the token, and that token gets them into particular spaces? Do you want to be able to commercialize the art up to a certain cap? Do you want to transfer ownership of the art entirely, the IP and the art entirely, by an assignment? I think the World of Women project does that, and then also attempts to assign or have a future assignment so that you can only ever assign the IP. So I just think understanding the differences and trying to align the goals of your project with the IP licenses and assignments is a key issue. And then understanding the legal formalities, which are different in the jurisdictions, but certainly if you want to assign in the UK, you need to it has to be in writing and signed on behalf of the assignor. Does your smart contract accomplish that? It's very easy to embed a handwritten contract into a smart contract, but it's just in making sure that you subscribe to the formalities.
There's a notice issue, right? I have to, as a secondary sale, I have to know that, hey, these terms and conditions are associated with that secondary sale. That's really tough to do right now. Anybody who's bought anything on OpenSea or any of the other exchanges, we don't read that kind of stuff. There's generally a hyperlink sometime that one of us lawyers has thought up, and you're supposed to read this before purchasing, but nobody does. That's what you're saying, right?
Absolutely, and so the particularly is from the first owner to the second owner, you're going to transfer a level of control. Then how much visibility do you have on any future transfers? Really interesting IP questions.
So bouncing off of that, the choice of law, where do we want to be? We've talked about Jersey, we've talked about BVI, we've talked about Panama, all these kind of things. I have a love-hate relationship with my own country and regulators there, but I do think the U.S. is trying in some local senses. Wyoming, for example, when their DAOs are, let's just say, cute, for example. But are we seeing anything else in Europe that really gets us exciting? Maybe moving forward in that NFT world. We talked about some new regulations coming up, but is that what we're focusing on? Is that where we think is the entire NFT world going to say that we're using European law?
Yeah, so I think the MiCA regulation will make a few things easier because it's a regulation across Europe. But this will not yet be about NFTs, unfortunately. So the NFT regulation will come later, but it will be a start. From the choice of law point of view, I think Nico can add a few views for customer and consumer protection.
Yes, especially in regards to consumer protection, this choice of law question is not really a question because, as soon as you start to target, for example, consumers in Germany, you still have to comply with German law, even if you are sitting in the US or in the UK. And that's maybe a very big problem for NFT projects because, what is your target audience? It's the whole world. And especially if we advise bigger brands, we decide with them which jurisdictions are your focus points, which are your main jurisdictions, and then you have to decide whether you want to comply with the consumer protection law in these countries, which is of course a huge challenge for you as an NFT project. But we all hate regulation in the European Union, but a good side of that is that most of the law is harmonized, and that if you start to comply with at least the very strict level, for example in Germany, you're on a very good way for compliance in most European countries, which is, at least from our point of view, a very good way. Yeah.
I agree. I think that in a lot of ways, the U.S. does look at you all as an opportunity of saying, oh, well, if we're good in Germany or we're good in, well, pre-Brexit, We had some interesting topics there, but it is a situation though that we have to kind of figure out the landscape for all of this stuff because it is a global issue, and taxes are a really global issue that continue to plague most of us who have gains or possibly even losses this year, or significant losses. And so, from a tax perspective, are we seeing a jurisdiction that is, the de facto tax haven, or something that we look at and say, hey, maybe we should set up the company there and enjoy those benefits from a choice of law tax perspective?
Yeah, that's a one thing. You can decide where you set up your company, and then your company is regulated by the tax laws in the country where the company resides. The other question is where you are selling your NFTs. So, and when you are, from a German point of view, selling NFTs in Germany to German customers, you're basically subject of German tax laws, VAT especially, which is 19% in Germany. And when you're selling goods or services, NFTs in Germany, you basically have to think that you have to pay those 19%, and that's something that you have to calculate in. And we always recommend to get a tax advisor on this because there are options to go around this. So, for example, if you can prove that your customer is not from Germany, and this is kind of hard to prove if you're minting directly from the contract, for example, but if you are able to prove it somehow, then you can convince the German tax authority that you don't have to pay VAT in Germany. So that's an issue you should think about before starting a project, how you set all this up, how your minting page looks like, what information you collect from your customers, and how you document all this.
We didn't go into this in our prior discussion, but the privacy issue related to GDPR and the U.S. is starting to develop its own privacy policy. We'll see how far those get with California leading the way. But that is an issue on the blockchain because the data is public. As long as it's a public chain, we can see a lot more transactionality than traditional Web 2. And we don't have, as far as I know, a way of complying with the law yet. And so at this point, I think we're all hoping it goes away or hoping no one notices. I mean, correct me if I'm wrong. Does anybody have any opinion on that?
No, I think it's a really good point. And I think one of the interesting sort of analogous situations which Michelle Fink wrote about one time was, I think it was Google Spain, where somebody wanted to sort of take their records off from a Google search. Yeah. And it was sufficient in that case to have the results removed from Google and not from the internet as a whole. So you could still find the information which the person, and it's all about the right to be forgotten. So I wonder if a similar situation will be allowed with blockchain. So yes, the information is always going to be there on the ledger, but if you can never find it, then is that going to be sufficient to comply with GDPR and UK GDPR?
I think it, especially involving .eth addresses or .ens addresses, it becomes a really big issue and something that we don't know how to address yet. So if you are building anything, be very careful what you use for those addresses, because that can be traced back to you, and whether it's the tax authority or a regulator or someone else going, hey, we know this is your wallet, look at all the transactions, look at all the VAT you owe us, look at all, possibly other criminality. We don't want to necessarily get into all of that kind of fun stuff, but that is another issue involving this complicated space. When we look at the choice of law and the tax consequences of everything from a U.S. perspective, it is such a situation that we have an onus as U.S. companies to report when we've made a transaction over a certain amount. And that is something that at this point is an absolute nightmare. And so we are looking at our UK and European counterparts to hopefully solve for us, because we don't know what to do. We're basically, once again, similar to the privacy policy issue, we're kind of putting our fingers in our ear and going, we can't comply, therefore, good luck. Does anybody have any ideas about how we could possibly comply with tax implications, especially as it relates to global NFT sales?
It's not solved at the moment, I think. What you can do is document everything as far as you can, and then get a lawyer, get a tax advisor, and with the documentation, you can try to convince the tax authorities of your view. So you can build your own view, how it's good for you, and then try to convince the tax authority that's the way to go at the moment.
Yeah, and I don't think there's any specific regulation in the UK. So it's just going to be assessed on a case-by-case basis. So yeah, I think that advice is very sensible. You'd just generally look at the facts, because that's what HMRC would do, and then ask yourself, does it look, which box does it fit into, and then it will be treated accordingly. So I think, yeah, just sort of common sense, but then ask a tax advisor. Would
you be opposed to having the smart contract possibly pull off a taxable amount or something as related? We have a project, for example, that is dealing with a nonprofit, right? And so that amount is 5%, 10% or something is being given to a nonprofit, a known 501c3. And so we can go to the tax authorities and say, hey, at least we paid this much in taxes. Are you guys looking at anything like that from a European or UK perspective?
It's an interesting idea, but I think I wouldn't do it hard-coded in a smart contract at the moment, because it's unclear and you need room to argument, and you don't want to put it all upfront in the contract.
That makes sense. Do you think it helps from a regulatory perspective of being outside of a security, or do you do that analysis as on a case-by-case basis of whether it's for-profit or non-profit?
It's a lot case by case, and you have to see what the actual NFT is doing, what it's connected to, what the roadmap is promising, what the founder team is promising on their website, on their Twitter, and the Discord, how they communicate with their investors. No,
participants.
Their customers.
So that's the most important thing, is just because you say you're a nonprofit, just because you believe you're doing a charitable purpose, does not mean that you just get to forget all of the laws that are involved in this space. It becomes such a complicated analysis, and I do truly hate that we have to have a legal panel on this stuff, because I do believe that you all are building really cool things, and I wish we had a very simple way of going through the process and telling you this is how you do it, but we can't. And this is what I'm trying to show you, is that every single case is a little bit different, especially as competitive as you all are. You're trying to game theory, and you're trying to be a little bit different than the next person. And so that in-game token that you have may be a security in some sense in the US, especially if you have a yield and you're doing it on behalf of a third party, and you're not actively participating in the market. And the issues with staking right now, staking is a huge issue that the SEC is looking at, and I can't tell you how many times that we've made the argument, if you're participating by staking, that is an active participation. In the European Union and in the UK, is that something that you guys are looking at, or what are the regulators saying from that perspective?
It depends.
The favorite lawyer answer.
Yeah. And it depends what happens when you stake. So when you stake and then you're promised a return, we get into all these troubles with regulation and possible securities or investment, crypto assets. But sometimes you only stake and then you get utility, and then we have the argument that we're out of the regulation. So if you only get another NFT that's maybe a picture, profile picture, or you get a print of your profile picture that you originally purchased, and then you have the argument that it's unregulated, that it's just utility. So it depends what the staking actually means in the project and what happens then.
But you still may have to pay taxes on it.
Yes. You always have to pay taxes.
So we have 4 minutes left. Is there anything that I missed, or is there anybody want to expound upon anything else?
Yeah, maybe on the data protection issue you discussed. So I would say that the GDPR issue is pretty easy to tackle, to be honest, because I mean it's typical normal e-commerce, and as soon as you set up an online shop where you sell goods, for example, there's a very clear framework how to implement a data protection policy, how to implement your terms of use. And I mean, to be honest, this legal framework is already existing, and you only have to apply this for your minting page, for example. So you need terms of use, and in this terms of use, you need to set out the IP license, for example. And you also need a data protection policy for that, for example. As soon as you have a minting website, there's a high risk that somebody could say that this minting process includes personal data. And based on that, you will need a privacy policy. And also if you have like a utility token where, for example, you, I don't know, get a hoodie or something like that, and you have to implement your address, for example, this is personal data, and for this you need a privacy policy. And what we notice is that big market players like Nike, Artifact, they really improved their game. I mean, if you, I don't know if you did it, but if you ordered the Artifact hoodie, there was a very good privacy policies. There were good terms of use, terms of sales, which clearly set out everything you need to comply with in e-commerce. And this is nothing new, to be honest. I mean, there is an existing framework for this, which can be easily applied for your whole e-commerce, minting, whatever experience.
And one more thing, a lot of projects use tools that are already existing. For example, Discord, Twitter, Google Forms for raffles. And these are all collecting personal data, and you need to include this in your privacy notice.
Yeah, it's the Web3 part of transacting outside of the website that gets a little sticky, and I think that's where we're trying to figure out from a legal perspective of how, when I sell you guys an NFT or you sell me an NFT, do I know what those privacy policies said or those terms and conditions say? We have 2 minutes. I'm going to open up the floor unless anybody has anything else.
I guess just to cover all bases here, so in regards to international personal jurisdiction issues as well, you know, should a cybercrime go awry or whatnot with regards to NFTs, coins, offerings, and whatnot? I'll keep it brief because we have 3 minutes, but it's essentially a three-part test to determine whether or not the country has legislative authority, the power to impose some sort of statute, rule, or regulation. The second factor would be to determine whether or not there's judicial authority, whether or not the courts, for instance, here in the United States, whether or not the courts in the United States have the power to bring in somebody from an outside country into the U.S. just so this way that said cybercrime could be heard. I guess, and then in addition to that is, you know, the enforcement capabilities as well with regards to the U.S. courts, whether or not the courts should there be a determination based off, you know, the judicial judge's decision, whether or not there's the possibility of enforcing said law or said decision. And so that's just kind of something to weigh there. I don't know if you guys have anything to...
Yeah, Nexus is important. Making sure that whatever government, whether it's mine or another one, has what we call Nexus over you. Did you actively participate in that market? Did you do a financial crime in that market? That is unfortunately something that you have to speak to lawyers about. Do not make that decision by yourself. You are not trained unless you have an Esquire or another type of law degree after your name. We have 50 seconds. Does anybody have anything important?
Yes, one thing.
Well.
Is there anybody here that likes to collect PO-apps? Because,
of course.
Yes, because we created a PO-app, so come to us after this panel and you get your PO-app, and we have a link in there to a blog post with a bit more information about our legal thoughts in this area. So.
That's amazing.
Perfect.
All right.
I guess that concludes.
Thank you.
Thank you.
Thank you.
Thank you.